Once the immigration judge has made a finding of removability against the respondent may then request from the immigration judge one or more forms of relief from removal. There are several types of relief from removal for which the respondent may be eligible: voluntary departure, asylum, cancellation of removal, waivers, adjustment of status, and in some cases, naturalization. I will now give a brief description of the various forms of relief from removal. Once again, this video is intended for informational purposes only. If you are in a removal proceeding, you should consult with a qualified immigration attorney to determine whether or not you are eligible for one of these forms of relief from removal. In some cases, an immigration judge may allow a respondent to depart the United States voluntarily at the respondent's own expense, meaning at no expense to the government, in order to avoid an order of deportation. The immigration judge can allow the respondent to depart the United States within a given period of time, usually up to a maximum of 120 days. To be eligible for voluntary departure, the respondent must indicate to the immigration judge that he is willing and able to depart the United States, that he has the financial means and all of the necessary travel documents to do so, and that he has not been convicted of an aggravated felony. Another form of relief from removal is asylum, and the related forms of relief known as withholding of removal and protection under the Convention Against Torture. Where a respondent can demonstrate to the immigration judge that he is afraid to or unwilling to return to his home country out of a fear of persecution in his home country, an immigration judge can allow that individual to remain in the United States. In order to be eligible for asylum, the respondent must demonstrate that he would be persecuted based on his membership in one of the following categories: race, religion, political opinion, membership in a particular social group, or nationality. If the respondent can demonstrate to the immigration judge that he would be persecuted based on his race, religion, political opinion, membership in a particular social group, or nationality, the immigration judge can grant him asylum and allow him to remain in the United States for his protection. Where the respondent is facing deportation based on a criminal conviction, he may be eligible for relief from removal in the form of a waiver. Waivers are generally available to an individual who's been convicted of a certain crime if he has a U.S. citizen or a permanent resident, close family member, who would suffer an unusual hardship based on his deportation from the United States. If the respondent is the beneficiary of an approved or pending employment-based or family-sponsored immigrant visa petition, the respondent may be eligible for relief from removal in the form of adjustment of status. In other words, based either on a family relationship or an offer of employment, the respondent may be able to adjust his status to become a permanent resident in order to avoid a deportation, as long as all of the eligibility requirements have been met. There are two forms of relief from removal known as cancellation of removal. First is cancellation of removal for certain permanent residents. There is also cancellation of removal for certain non-permanent residents. If the respondent previously held status of permanent resident, he may be eligible for cancellation of removal for certain permanent residents. In order to be eligible for cancellation of removal for certain permanent residents, the respondent must have been a permanent resident for at least 5 years prior to being served with a notice to appear. he must have resided continuously in the United States for a period of at least 7 years in any status. The respondent must not have been convicted of an aggravated felony. If the immigration judge grants an application for cancellation of removal, then the respondent will continue to be a permanent resident and will not be deported from the United States. If the respondent was not previously a permanent resident, he may still be eligible for cancellation of removal for certain non-permanent residents. To be eligible for cancellation of removal for non-permanent residents, the respondent must prove that he was physically present in the United States for a period of at least 10 years prior to having been served with the notice to appear. The respondent must also prove that he's a person of good moral character, meaning that he's not been convicted of certain crimes such as aggravated felonies or crimes involving moral turpitude. The respondent must also prove that he has a U.S. citizen or permanent resident close family member who would suffer an extreme and unusual hardship if the respondent were to be deported from the United States. If the immigration judge grants the cancellation of removal, then the respondent will be granted the status of permanent resident and will not be deported from the United States. Finally, in certain cases, a respondent may be eligible for naturalization to become a U.S. citizen, except for the fact that he is currently in a removal proceeding. Under these circumstances, an immigration judge may terminate immigration proceedings to allow for the respondent to apply for naturalization. If the naturalization is granted, the respondent will no longer be removable from the United States. On the other hand, if the application for naturalization were to be denied, then the immigration court can reinstate the removal proceedings and the government can still seek to remove the respondent from the United States. Even if a respondent demonstrates to the immigration judge that he meets all of the eligibility requirements for one or more forms of relief, the immigration judge is not required to grant that relief unless the immigration judge feels that the respondent is deserving of such relief within the judge's discretion. The individual or merits hearing is the trial at which the respondent and the government's attorneys each will present their documentary evidence, their witness testimony, and their arguments in support of their case. The government's attorneys will be asking the immigration judge to make a finding of removability and order that the respondent be deported from the United States. The respondent, on the other hand, will either be asking for a finding that he is not removable, or if he is removable, he'll be asking the judge to grant one or more forms of relief from removal. After hearing all of the evidence, testimony, and arguments from both sides, the immigration judge will enter his or her decision of either removal or granting relief from removal. After the immigration judge has entered his or her decision, if either party is not satisfied with that decision, they can file an appeal with the Board of Immigration Appeals within 30 days after the date on which the immigration judge enters his or her decision. Alternatively, either party may file with the immigration judge a motion to reopen or a motion to reconsider the judge's decision. A complete discussion of appeals and motions to reopen or motions to reconsider is beyond the scope of this short video presentation. However, please visit www.immigrationinfosite.com for more information on these issues. To conclude, if you're facing a charge of removal, this is a very serious issue, and you should consult with a qualified immigration attorney in your area to determine whether you are eligible for any form of relief from removal. If you would like more information on this or any other immigration law subject, please visit us at www.immigrationinfosite.com. Thank you.